Right. Hi, everyone. Thanks for joining us for today's webinar, Patent Litigation Readiness Protecting Your MedTech Product. My name is Jen Osborne with MassMedic, and I would like to give a special thank you to our sponsor, Greenberg Traurig. Before we dive in, I wanted to cover a few housekeeping items today. As a reminder, the session is being recorded. We'll be sharing the recording and PowerPoint slides with you afterwards. Please feel free to submit questions at any time during the webinar using the Q&A box and not the chat box. We'll try to address as many questions as we can at the end. We have a great program lined up for you today. And with that, I'll turn it over to Dave Dykman to kick us off.
Thanks, Jen, and thank you to MassMedic for allowing us to present on really patent litigation trends. And it's a very pertinent time to be having this discussion today. There are some big trends that are happening in the last months and even in the last few weeks in related to patent litigation. So it's very timely to be doing now. And I'm a patent attorney at Greenberg Traurig, based in the firm's Boston office, and I've been involved in MassMedic for about 25 years now. In the last few years, I've been lucky enough to serve on the board of directors under the excellent leadership of Brian Johnson and Rachel Robinson, and MassMedic just continues to grow from strength to strength. So we're very proud of the work that everybody at MassMedic is doing. And just before we get into it, here's a little infomercial. Greenberg Traurig, we're a large international law firm in the top 10 biggest firms in the world, 3,000 lawyers, 51 locations in 15 countries. I'm based in our Boston office. Our other speakers are based in Chicago and Boston as well. The firm just opened its most recent offices. Number 50 was in Abu Dhabi, which is a lot of exciting life science things are actually going on in the Middle East right now. And also Aspen, Colorado, which might not have as much medtech, but much better skiing. And I co-chair the firm's life science and medical technology practice. I'm a biomedical engineer who became a patent lawyer, so I love medical devices and they're near and dear to my heart. And our life science and medical technology team is about 200 lawyers across all of our offices and across all the practice groups. And we help our life science and medical technology and medical device companies really through their whole life cycle. We've had corporations that were formed in one of our conference rooms. We filed the patents to protect them. We help them get funding. We try to help them avoid litigation, which is a lot of today's call. But when you do get pulled into litigation, which sometimes is unavoidable, you want to have the best litigation team. And we can do everything from employment law to international trade to FDA, regulatory compliance, and, data privacy, as that's becoming more and more important. And we have a super strong AI kind of MedTech patent attorney team too, which has really been a huge trend that's changing everything, I think, in the industry this year in 2025. So that's our firm. Please feel free to reach out to us. There is the contact information of all three of the speakers. Unfortunately, Jeff Mann was going to be our industry speaker today, but he had an unavoidable conflict and sends his regrets. But we did speak with him and incorporate a lot of his comments as general counsel at Embecta Corporation, in the diabetes space. And so we'll incorporate his comments in there as well. And our two speakers today, I will give them a brief introduction and ask them to talk about themselves. But Matt Levenstein is an IP litigator specializing in patent and trade secret litigation, among others, in our Chicago office. So Matt, tell us a little bit more about your practice and a trend you're seeing related to medical device patent litigation.
Yeah, thanks, Dave. I'm a little troubled by how much older I look on camera than I do in that picture on the slide. But other than that, yeah, I'm really happy to be here. Glad everyone could join us. As Dave said, I'm an IP litigator and trial attorney. I've been with Greenberg for over 15 years. I have a wide-ranging IP litigation practice. I've done a lot of medical tech products in the patents and the trade secret space, cases about bone cement, forehead thermometers, hospital beds. So I've had a good variety of cases. In terms of trends that I'm seeing in the medtech space, I think what I continue to marvel at the most is the growth in wearables, and in particular, the way that the public has perceived wearables and how it's changed over the last few years. There used to be a stigma, I think, associated with wearables being an actual medical device and signify or signaling sickness or unhealthiness. And now we see wearables as a lifestyle product, not just a medical device product. And it signals health and fitness and proactivity. And why that's important for patent litigation is that we now see wearables as a target for patent litigation, and particularly with non-practicing entities or patent trolls. And what we're seeing is that as that market has grown, it's attracting more and more interest from NPEs, and that's not going to change. The bigger the market, the more consumer facing the industry is, which the wearables market is, the more interest it's going to garner from NPEs. And we've already seen that, and I think that's going to continue. And so with that, I'll turn it over to my other co-presenter, David, who is going to introduce himself.
Sure. Thank you for joining, everyone. My name is David McGee. I'm a patent litigator in Greenberg's Boston office. My practice is primarily tech and med tech companies. I've practiced in a variety of the district courts around the United States, as well as before the ITC and Patent Trial and Appeal Board. I would just echo, what Matt was going into. The new sort of technology entrance into the med tech space, I think is just going to increase more. And with them come the challenges that the tech industry has faced over the years in terms of non-practicing entities, which we're going to go into some in this presentation today. I think Matt summed it up very well. And, with that, I think that we can just get into the meat of it. David?
I think we will go ahead and do that. We'll put up the agenda we have now, and I think Mathematic is going to share an article link in the chat, an article that Matt and I wrote that kind of was a precursor to this webinar. So you'll have a little light reading for um, after the webinar, and we'll also share our slides. Mathematic will do that to everybody who registered. And please feel free to reach out to us if you have any questions after this, and put questions in the chat and we'll answer them. But we grouped the agenda into three main categories. The latest trends in MedTech patent litigation. There's a lot going on. We'll get into that. And then for all the companies, how do you manage your litigation risk, reduce your exposure, and protect your IP so that either to avoid a fight, or if you're in a fight, you've got the right equipment to win it. And patent litigation is the most expensive lawsuit that a company can face. We'll get into some of the fees, but even the attorney's fees alone are in the millions of dollars, and the verdicts, as you see in the headlines, can be multi-million dollars. So there's a whole cottage industry that's kind of perked up in the last few years about financing patent litigation and really preparing for these high stakes bet the company disputes. So I think we're going to go ahead and get right into the content here. I'll turn it over to David McGee to talk about some of the trends we're seeing in medtech patent litigation.
Great. Thanks, David. So the good news is that the medtech industry is itself booming, projected to grow from 810 billion in 2024 to 1.3 trillion in 2029. And this is largely fueled by AI, robotics, and minimally invasive technologies, along with the wearables that we touched on at the intro. The bad side of it is the growth has made the medtech industry a prime target for patent litigation, which often chases deep-pocketed industries as high-stakes intellectual property and life-saving devices amplify settlement values in litigation. What we're seeing is an overall increase in patent litigation in both the US and abroad. Patent disputes tend to be countercyclical. So when the broader economy slows or uncertainty increases, patent litigation often ticks up. And the reason for this is that companies are looking for alternative revenue streams, and patents become a more active asset. Those alternative revenue streams can come in a variety of contexts, but two of the more common scenarios, which we'll give greater detail on, are companies leveraging their own IP portfolios against competitors, as well as companies selling off IP assets to third party, which then leverage them as non-practicing entities. The second trend that we're seeing is a big change in activity at the PTAB. And we have a separate slide on that I think Matt's going to go into. So David, next slide, please.
Thank you, David. So let me give you a very brief background on the Patent Trial and Appeal Board, or the PTAB, and why it's important here. So the Patent Trial and Appeal Board, it is a specialized tribunal within the United States Patent and Trademark Office. And what they do is they review the validity of patents that have already issued, at least for, that's largely what they do. And you can think of it as a quality control checkpoint for patents. And what makes the PTAB so important is because when there is a dispute over a patent, rather than that fight taking place in a district court, which is a very slow and a very expensive proceeding, companies can ask the PTAB to reevaluate whether a patent should have been issued in the first place. And if the PTAB does invalidate a patent, basically saying patent's no good, then you can't assert that patent in litigation or continue to assert that patent if a litigation has already started. And so the PTAB, especially in recent years, it's played an outsized role in determining which patent disputes are ultimately resolved on the quick and cheap side before the PTAB, and which ones become long, expensive court battles in a district court. And that has what I think are obvious implications for your patent litigation strategy. And what we've seen lately is really a sea change in the number of disputes that the PTAB is willing to resolve. And lately, the PTAB has said, no, we are not going to take on these proceedings and decide whether these already issued patents really deserve to be issued in the first place. For years, the PTAB had more or less the opposite approach of saying, yeah, look, we're going to be proactive about this. We're going to take a look at it. We're going to give litigants an alternative to district court litigation to try to resolve their patent disputes more quickly and cheaply. Not so. That's now changed, and that is a change that has happened very, very quickly over the last, 6 months, and really even within the last month and few weeks, we're seeing these changes in real time happen. The patent office is saying, no, go to district court. We're not going to look at your challenge. And that's a problem for people who used and relied on the PTAB as a forum to quickly and cheaply resolve a patent dispute that they found themselves in. But here's the key. Just as we've quickly been seeing the change in the PTAB from being willing to entertain these proceedings to assess patent validity to now say no, that can shift back again. And so what that means is you need to have someone in your corner that is on top of the changing PTAB policy. Because just as quickly as it's changed to say the PTAB is not a great option or not as good an option as it used to be as a defendant in a patent infringement case, or on the flip side, it's great for a patent plaintiff. It means the PTAB is not a great opportunity for a defendant to run to avoid a patent litigation. That can flip back the other way. So what's critical is that you have someone in your corner that knows PTAB policy, know how it's changing, and can advise you accordingly. So with that, I'll turn it back to David to see if he has any other points that he wants to mention about the PTAB, or alternatively move on to his next trend in MedTech patent lit.
Yeah, just a couple points there. One is that on the PTAB slide that we just showed you, we do have some content. There's probably a weird transition in the slides, so that will be in the slides that we send to you. But more to the point, Matt touches on the ever-changing, evolving landscape in the PTAB, and so it is important for you to interface with counsel that is staying on top of the changing landscape. For example, much of what Matt is talking about occurs in the IPR space, which has historically been the vehicle that you would use when you're in patent litigation to challenge the validity of a patent. Now that that's being sort of pulled back and less IPRs are being instituted, we have to look at the other vehicles that are available to us, and those would include patent reexamination, as well as patent grant reviews, which happen very early after a patent is issued. So, in other words, the director right now is saying we're going to give a patent a presumption of validity. And the longer that that patent has been in existence, the more reluctant the patent office is going to be to institute further review of that patent. So the PGR process is a process that happens very quickly after a patent grant. So it's imperative for you as a company to monitor the patents that are being issued by your competitors and make a decision about whether that patent is something that needs to be challenged based on your knowledge of the prior art and the other arts that are out there to make sure the claims that are being issued in patents are not overly broad and will impact your business environment. So I think that, those points are, important to keep in mind. Moving on, the next thing that we wanted to talk about is the expansion of the European Unified Patent Court. And the Unified Patent Court is a central venue in Europe where single cases can impact patents or patent rights across 18 European member states. So what's critical to understand here is that the UPC has a very powerful remedy when you're successful, and that is patent or pan-European injunctions. So this means that a single UPC can issue an injunction that can stop a defendant from making, using, selling infringing products across the EU. This makes the UPC a very attractive forum for plaintiffs, both within the MedTech space and elsewhere, particularly in circumstances where MedTech participants launch products in European markets first and follow along with product launches in the United States. So the UPC may be the first court where a patent challenge is, or a patent case is filed against a product that was launched in the European market first. So we're seeing plaintiffs flock to the UPC. There's been nearly 1,000 cases filed in the short 2 years that the UPC has been in existence, and we think that trend is only going to increase. Next, David Dykman touched on this, but we're seeing higher litigation costs, which were already substantial, as many of you may know and experienced. Median patent litigation costs in the US hover between $3 and $5 million for trial and appeal, and that's for cases between or with dollar values at risk between 10 and 25 million. Cases that have higher dollars at risk often demand more resources, and so litigation costs can increase with those. But the truth is,
David, that's a really good point you just raised, and I want to make sure that comes through. It's not just the dollars here. The more dollars you spend on something, the more interest it garners from the business, right? And lawsuits, even small ones, are huge resource sinks. And the more money you're spending on it, it's going to be an even greater resource sink. It takes leadership attention. It can impact company morale. Stakeholders, investors want to get involved. They want to be kept up to date on what's happening. And so it's not just the litigation cost in dollars, but in resources as well.
Yeah. And the venue selected also comes into play here in terms of the timeline where those dollars will be spent. For example, in the Texas venues with their rapid litigation calendars,
Mhm.
the costs for litigation tasks will occur earlier in a case, whereas venues such as Delaware with more protracted calendars realize those litigation or milestones later in a case, so the litigation budget can be spread out farther. So the venue does still play quite an important factor in when the costs come into play. And as Matt said, when the management of a company would need to pay a lot of attention to the case. So layered on top of all this is third-party funding. Um, there's certainly an increase from private equity, family offices, investment vehicles looking for other ways to invest their clients' funds to get a return. There's an increase of these types of investment vehicles investing in litigation funding, which is injecting more capital into the litigation space and enabling certain plaintiffs to pursue larger and more complex cases. The private equity firms, the family offices are increasingly employing individuals that have patent background and are evaluating cases for those investments. We'll talk about litigation funding in more detail, but for now, it's important to understand that more litigation funding begets more lawsuits in litigation. I think taken together, all these trends and perhaps most important, the theme is that the growing need for proactive risk management, companies that actively monitor their exposure, assess threats early, and plan defensively are far better positioned to control costs and avoid surprises in the litigation timeline. Understanding these dynamics is critical in today's more active, more aggressive, and better funded enforcement environments. David, next slide. So this table has a variety of metrics that are essentially in real time. The patent litigation in the United States has increased significantly from 2024 to 2025. And this is patent litigation in general, not just in the MedTech space. It's a 22% increase in case filings. The percentage of medical related patent cases has increased from approximately 10% to 13 to 14% over the last several years.
Hey, Dave,
Yeah,
can I touch on that for a moment?
yeah, sure.
So I think that that's a really interesting statistic, and I want to make sure that everybody understands it. We're talking about the out of the total number of patent cases, it's increased from 10% medical related to 13, 14%. That doesn't mean a 3 to 4% increase. That's like a third increase. So medical related cases are now comprising a third more of the total patent cases than they did 4 or 5 years ago. That is a massive increase. Yes, it's still a small overall part of the entire patent litigation, spectrum of cases that are filed, but it's a massive increase that we've seen in just a few years, and that's going to continue, we think.
Yeah, and I think that the damages support that. Total damages
Mhm.
awards in 2024 reached a record $4.3 billion, with the first half of 2025 accounting for a similar 1.9, almost $2 billion. So these are historically high damage awards, and many big payouts are happening in the high tech and biopharma spaces in particular. But that's expected to move into the med tech space. I think that a notable example that had a $634 million verdict was the Apple case, where they were found to infringe Masimo's patents on blood oxygen monitoring technologies. So while Apple may still be considered a tech case, this is one of the examples where wearables and health conscious technology is moving more into the med tech space. And the patents involved in that are being asserted and being purchased for assertion. So it's a space that is increasing and needs to be monitored. Um, so intelligence, I don't think anybody can have a presentation these days without talking about artificial intelligence, but it is becoming a focal point in patent litigation. It contributed to a 26% growth in 2025. And so in the patent prosecution space, it's also becoming more and more significant. And I think, David Dykman, you could probably touch on the rapid increase in AI patents that you're seeing being
Yeah,
sought
I
by.
think that's right. If you think about patent litigation, to get to patent litigation, you've got to have patent prosecution. You need to be filing patent applications, and the AI patent explosion, we're in the midst of it now. If you think about it, it's a really newer field over the last few years, and there is a rush to file patents in the patent office to get there first. And if you think about it, there's a lot of white space, and in many ways, it's kind of a land grab, if you will. And I think as AI is getting more into life sciences and more in particular to MedTech, we're seeing more patent filings in the last few years in that space, and our firm has kind of been at the forefront of that with some really creative AI, MedTech, and health tech patent strategies that we've gotten great results on. But I think we're going to see that down the road, whether it's 3 years, 5 years, 10 years, there's going to be more and more of kind of AI and tech litigation. And we're already seeing that growth kind of fueled by the increase in the number of patent filings in that space.
Yeah, and just to put a little bit of color on it, in 2024, and this isn't specific to the med tech space, but there were over 8,700 AI-related patent applications filed in 2024. So I think when the 2025 numbers come out, those numbers will be even higher by a significant amount. So stay tuned for that. I think the final point I want to make on this slide relates to non-practicing entities or NPEs. And they've played a pivotal role in the surge of litigation that we've seen. And they account for approximately 14% of the increase as at least in as of early 2024. And the statistics I've seen for 2025 um, support that even further. I think that the numbers are going to be staggering because again, the the NPE space gets more busy when the economy is a little bit more uncertain because companies are monetizing their patents and oftentimes they end up in NPEs who then assert them. So NPE cases represent 63.7% of the suits in Texas. Um, and the popular venues remain the Eastern District of Texas and the Western District of Texas. So this trend underscores the growing financial stake and strategic maneuvering that the NPEs are taking. And I think we're going to touch on that a little bit more as well. David, next slide. So with NPEs, this is a little bit more specific to the med tech space. So there are several factors that have influenced NPE activity in the med tech space. One is patent acquisitions from legacy players. So, as I said, NPEs are snapping up IP from pharma and device companies. As an example, company Auto Injection, backed by Anjay Venture Partners, bought approximately 70 assets from Sanofi in 2024 and immediately started asserting those patents against industry participants in 11 litigations, and that happened by mid 2025. So happens very quickly once NPE gets patents in their possession. They move quickly to try to monetize those. So another example from the consumer electronics into med tech space. We've seen consumer electronic patents being asserted against Medtronic, GE, Siemens, and Abbott in at least 31 cases in 2025. So, as the technology space and the med tech space continue to merge, some of the prior technology patents that were not included in the med tech space are now being asserted. And these could include anything from wireless transmission technologies to video and audio patents that the technology space has been grappling with for a number of years. The NPEs focus on high growth subsectors. They're zeroing in on AI-enabled technology. So again, imaging, diagnostics, where the patent values in companies are increasing. The European Patent Office saw 15,000 medtech applications in 24, with AI comprising a growing share of those. Litigation-friendly environments is another factor. We mentioned Texas, and there are a number of different entities. The Moskowitz family LLC, so there's a family office, is very active in asserting patents against the med tech industry. And I think that and the increase in private equity participation is only going to fuel further litigation. Some notable examples of NPE campaigns that are out there that some of you have probably received love letters from. Patent Armory, that company filed, or that entity filed 110 cases in 2023 and added 21 more in the last year. So it's continuing to be very aggressive. VDPP has shifted into the medtech space, and it's sued companies over 3D viewing platforms. There have been 84 cases since 2019, and 31 of them are currently active. I mentioned the Moskowitz family private office, and that is expected to continue as well. So what's the implications for the medtech ecosystem? Well, for inventors and innovators, it's increased defensive patenting and insurance costs. So smaller firms that may be developing robotics or wearables are hit hardest because of the costs associated with litigation in the defense of their technologies. And that's projected to increase with digital therapeutics through 2025. Matt, do you have anything you want to add to these?
Not really, David. I think you hit the nail on the head. I mean, this is not going away. It's only going to grow. The MPEs will always find the biggest opportunities, and right now, medtech is one of them. And so we're going to see that continue until something changes to the broader medtech market, which nothing in the current economic trends show is going to happen anytime soon.
Yeah, and I would agree with that. I think, we're seeing a trend over the last decade that's only been accelerating of, there's a lot of major medical device players that have massive, massive patent portfolios, hundreds or thousands of patents that they spent a lot of money to get. especially as a product ages out or doesn't get commercialized, they still have their patent costs because you have to file those before commercialization. And we're seeing a much higher willingness as we saw kind of Sanofi selling patents, kind of knowing what was going to happen, that this entity was going to buy them and try to enforce them. But the addition to their bottom line was too good to pass up. And these big companies are often they're happier um, to have someone else enforcing that. So let's move on to the next slide. We're going to talk about how do you manage this litigation risk? How do you reduce your exposure? And how can you protect your IP?
Yeah, thank you, Dave. And the good thing is, so now that we've sufficiently either scared some of you or enticed some of you, the good thing is there's lots of things you can do to protect yourself. And the first bullet we have here is conducting regular freedom to operate searches. And so what those are essentially, it means checking whether any existing patents that are already out there could either block or limit or otherwise complicate a future product launch or a future product feature that you want to introduce into your product. It's a way to protect yourself proactively before the product hits the market, before you're hit with the lawsuit, saying you can't do what you've already put hundreds of thousands, millions, tens of millions of dollars into. And so the key here is doing this early and doing it routinely. During product development, during feature development, the freedom to operate searches to see what else is out there catches the issues before the significant investment has been made. It allows you to shift or change before you've already put in all of that capital into the product feature or the product launch. And it's this early identification that helps keep the costs down. And there's other bonuses too. So not only are you identifying where is a safe space for you to operate relative to your competitors in the market, it's also telling you where those white space opportunities are to further the innovation, to fill out the gaps and take as much space as you can for yourself without stepping on somebody else's rights. I don't know, David, feel free to jump in on any of these points, but I was going to move on to vetting and monitoring your suppliers, unless you guys have something to add.
Nope, I think you're good.
Okay. So the next point, vetting and monitoring your suppliers. Another practical, sometimes difficult in practice to do, but so important to help manage your risk and reduce your exposure. Every single third-party component that is part of your product is a potential litigation trigger. And the scary thing is, even if you had nothing to do with the design or development of a particular component, if it's in your product and it infringes somebody else's patent, you've committed an infringing act under the Patent Act. You can be sued for that component. And so that's why ongoing supplier diligence is absolutely critical. You have to know your supplier's history. You have to know, are they financially stable? You should investigate what their prior litigation record is. Do they honor their indemnity obligations? And if you don't know the answers to these questions, you should ask them. Ask your suppliers. And the ultimate goal here is you want strong indemnity protection that's tailored to the risk posed by the supplier's component that they're putting into your product. You can't just assume that boilerplate indemnity language is enough. And companies that do this, that vet and monitor their suppliers, they do a much better job of making sure they don't inadvertently get stuck on the hook paying for a litigation or a damages award that's caused by somebody else's component. And those that don't do this, those are the calls that we get. Those are the calls that David and I get saying, uh-oh, we've just been sued. We don't have anything to do with this component. What do we do now? And that's the situation that you don't want to find yourself in and that you can avoid with proactively vetting and monitoring your suppliers. So the next point, maintaining thorough development records. It's not really an exciting point, but it is really important. Keeping clear like design files, meeting notes, prototyping, test results, and logs of all of those things protect you when someone challenges your product and says that it infringes. And it's particularly helpful in the situation where someone says that you copied their technology. A well-kept development record shows that your work was independent. And in a patent case, that's critical. There's something in patent law called willful infringement. And what that means is if a plaintiff sues you and says that not only did you infringe our patent, but you intentionally infringed it, you knew we had a patent and you did it anyway, that can result in the court tripling the damages amount. The best way to counter a claim of willful infringement is to be able to tell the judge, tell the jury, tell plaintiff's counsel, tell everybody, no, 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 we didn't copy, we did this ourselves. Here's how we did it. Here are our logs, here are our lab notes, here's all those internal documentation showing that we didn't use your technology, we did it on our own. So it's critical to invest in the right physical and IT infrastructure to preserve those historical product development materials, and critically, not just to preserve it, but to make sure they're accessible when you need them. Next point, training your employees. We see this all the time. In a lawsuit, an email from the defendant gets shown up at trial. And there's 10,000 emails that your company has exchanged back and forth about your product development. But the one email that gets shown first during a trial is the email where two of the lead engineers or lead scientists have said, this is kind of similar to what so-and-so is doing. Those 9,999 emails that say the opposite, they don't matter. It's the one bad email that can sink a case. So what this means is you need to train your employees to be really careful about their written communications. And I know this is a distraction. So the way that I tell my clients to do the training, is to focus on two key groups of documents. It's documents when you're talking about competitor patents and when you're talking about competitor products. Anytime you're doing that, that engineer, that scientist should have, a red light going off in their head saying, be real careful here, because anything I say about a competitor patent, a competitor product, I should assume that it's going to show up in any future lawsuit. So be mindful of that. We don't want to take our engineers and our scientists and turn them into lawyers. That's not the goal. But just a couple of key tweaks of their mindset when talking about their competitors can go a long way if the company finds itself in a litigation down the road. Next
And
point.
for bigger companies, our firm does a lot of trainings, like an hour-long training we have specifically about being careful in written communications and showing a lot of these exhibits that get blown up at trial on the big screen, and a lot of times, often too, they're even a joke in an email. Someone shows a competitor product and someone jokes back, "Oh, well, that's exactly what we're doing," and that's a hard bell to unring when you see that. So,
Absolutely. Couldn't agree more. Next points, protecting your IP. This, I think, is something that we forget. We tend to separate out patent litigation from patent prosecution, but really they need to be considered collectively, and there needs to be a holistic approach to intellectual property to protect yourself. Because a strong patent portfolio protects you from a litigation standpoint. And that's in a number of ways. Number one, it gives you that space. It gives you the freedom to operate, to launch products, and to enter markets without fear of being blocked. And yeah, look, there's no guarantees that somebody won't still try to sue you, but by carving out your own space through your own patents, you minimize that risk. And secondly, if you find yourself on the receiving end of what David called a love letter or a cease and desist, having defensive patents, having your own patents, they act as a shield. Companies are less likely to sue you if what you're doing and what you've protected you can then sue them for. So while that isn't super useful in the NPE context, it's immensely useful against competitors and those actively participating in the market as well. By having your own patents, you can counter-assert or use as leverage in a settlement negotiation that that increases the likelihood of a favorable outcome. And the final point on this
I
is
think
is
on
don't
that one, the way that you
yeah,
can think about patents is it's almost like the analogy for the Cold War. If one company has a lot of patents and the other company has a bunch too, they're less likely to sue each other because they know if they file one lawsuit, they might get a bigger one back in return. So it does kind of have a deterrent kind of standoff effect.
absolutely, absolutely. And the next point dovetails with that specifically. You need to make sure you are pursuing patent protection in the appropriate geographies. Patents are territorial, we know that. But you'd be surprised how often people forget to protect their patents in the markets where they do business internationally or hope to do significant business. And on top of that, it's not just where you want to make the sales, it's where you're operating. If certain components are manufactured overseas or the products are manufactured overseas, you need patent protection there too. Because you don't know what unscrupulous manufacturers are going to do when they think you're not looking. And so the best way to protect yourself is to show people that you're paying attention. And you pay attention by seeking patent protection, not only in the final market, but everywhere along the chain. And obviously, every situation is different. And that's what good counsel can help you to do, which dovetails with our last point. Good counsel can help you prioritize where you should be filing. And that's why it's critical to involve experienced IP counsel, not only litigation counsel, but prosecution counsel as well. And the reason for that in the litigation context, I think is self-explanatory, or self-evident rather. IP problems, like most problems, are much cheaper to prevent than they are to fix. And by the time you're on a receiving end of a lawsuit, it can be very difficult to fix some of the foundational mistakes that maybe you've made along the way. That window is largely closed. So early engagement with counsel, both prosecution and litigation, is critical. That's how you protect yourself. That's how you manage the risk. That's how you reduce the exposure. I think we're ready for the next slide.
Talk a little bit about how do you prepare for high stakes litigation and how do you pay for it?
Yeah, so while certainly the things we talked about on the last slide um, apply largely to a would-be patent defendant, certainly there are aspects of it that are applicable to plaintiffs as well. And how here now on this slide, we're going to kind of take the flip of that. We're going to focus more on the what do you do if you're interested in filing a patent action? What do you do before you decide to file that complaint? And so I think we've made it clear through some of the earlier slides that David went through that patent litigation, it's expensive, it's unpredictable, it's disruptive to your business, but sometimes it's necessary. And sometimes it's important as a plaintiff that you do that and enforce the patents that you have. But careful planning ahead of time really reduces your exposure as a plaintiff. It reduces the operational risk, it reduces the financial risk. And again, there's some concrete steps that you can take before you file suit that will help you along the way. And the principal thing that you can do is define your litigation goal clearly and make sure that it aligns with your business strategy. So in a patent litigation, you should know going in, what does success look like? Is success developing a revenue stream? Is it blocking a competitor? Is it sending a deterrent message to other would-be, infringers? Are you sending a signal to your investors that you're proud of your technology, you think it's valuable, and you're willing to protect it and defend it? Know what those goals are ahead of time. And many times a single patent case can achieve multiple goals at the same time. But just because you can sue doesn't necessarily mean that you should sue. You have to know your goals, and you really have to make sure that that case that you want to file complements your business, complements the products you want to launch, the partnerships you have, and ultimately your long-term company objectives. Will a litigation, for example, alienate your customers or your investors? Will it divert the limited resources you have and leadership attention during a critical time in your business? Will your engineers that are working on high priority special projects resent having their time days being taken for deposition preparation and trial preparation and testimony? If you think about these things ahead of time, you can better decide whether, number one, whether you want to file a lawsuit now, or I should say, whether you want to file a lawsuit, and two, is now the right time to do it. But let's say you do all of those things and you conclude, yes, now's the right time. This is what we need to do. It's aligned with our business objectives. We need to file suit. The next question is, well, how do we fund this litigation? And again, that's not something that you should decide after you filed your lawsuit. That needs to be addressed ahead of time. As David mentioned before, MedTech litigation can very quickly escalate into multi-million dollar disputes just from a litigation cost standpoint. Litigation drains cash. It can compromise financial performance if the case is big and the company is small. And so that's why you need a plan for how to fund your litigation from the get-go. And so the first option is obviously you can fund it internally. And that's great in the sense that it gives you complete control over the litigation, but it strains cash flow and it diverts research from other projects, like I just mentioned. Now, the other option is third-party financing. And third-party financing or litigation funding, it has grown tremendously over the last decade. And it's had an enormous impact on patent litigation. It gives companies that otherwise would not have reasonable access to filing a patent lawsuit, that access. But of course, when you take someone else's cash to finance a litigation, there's strings attached to that. Funders receive, a cut of the future payout of the settlement, of the judgments. They're going to expect that obviously for putting up their capital. So while your financial risk is lower when you do a third-party litigation finance, the upside's lower too. So you have to balance those two things. But what makes litigation financing a really desirable option is when the goal for the litigation isn't only to get money, but also to achieve, one of those other goals, like keeping a competitor out of your market. So when that's not purely financial based, litigation financing could be a great option because you keep what's important to you, which is keeping the competitor out without having that huge outlay of cash. And so you have to decide what's more important to you. Is it the control over the litigation? Is it keeping cash flow, strains at a minimum? Is it ultimately, are you concerned about giving up control over the litigation where it might ultimately end up in settlement? So you have to consider these things as you decide how to finance the litigation. And going along with that, you have to build in realistic budgets and you have to model your possible outcomes. And this is something you should expect from your outside counsel. It's not enough for counsel to say it's going to be $3 million through trial. You need to have, and you should demand a much more detailed, comprehensive budget that considers a range of outcomes and a range of settlement scenarios and a range of court judgments of what they could be and appeals, and budgeted all for all those options. And the reason why you need that is because modeling those different scenarios, that helps your business make informed decisions quickly. When you have that information handy, you can make decisions much quicker. Without that information, it makes it very difficult to be nimble in a litigation, which is particularly important especially as the litigations grow and the damages figures are climbing. You want to be able to make a decision quickly about whether or not a settlement makes sense. Strike while the iron's hot. And that goes for plaintiffs as well as defendants. Again, we've already touched on the last 2 points, but I think they're equally applicable in the plaintiff side of things. Keeping strong documentation is just as important from a plaintiff side as well. Now that it's time for your company to tell its story to the judge or to the jury, those detailed design notes, testing records, project timelines, all the things that show all the work that went in and all that effort that went into developing that product, that's gold. And you need to have that available to you to support your case and to support your story at trial. And finally, again, just like before, hiring an experienced team before a dispute arises is critical. You want to have all your ducks in a row before you drop that complaint. And good counsel will do that for you. You will have already started that process of collecting your documents for discovery. You'll have already started thinking about where the inflection points are in the case and where we can make overtures to try to settle things. Um, Only by taking a proactive approach with counsel that knows what they're doing can you set yourself up for success in a litigation. So I think with that, interested in David and Dave's comments, where we can move on to the next slide.
I think we're going to move
Sure.
on just in terms of timing and trying to get everybody out under the time constraints that we're operating under. So I'm going to hit the high points on these next couple of slides. So um, IP has become a significant part of the investment thesis for investors. It's not unusual for between 30 and 70% of a company's valuation to be assigned or be given to its IP portfolio. And that portfolio includes not just patents, but trade secrets, data exclusivity, trademarks, copyright. So all of those. Um, Funders often have their own IP due diligence teams. So having a management in the company that also understands these issues is vital. You need to understand the IP issues. You can't just delegate them out. You need to understand freedom of operation risks, remaining patent life, what pending continuations are out there, not just yours, but your competitors, and how can they look at your product and craft their continuation applications to try to cover it. Ownership history of the patents, any incoming litigation or patent challenges out there that have involved the patents that you're looking at is very important. And another thing that we are seeing a huge amount of is standard essential patent litigation and standard essential adjacent patent litigation, where the patent may not be in the standard itself, but is operating right outside of it and may be an improvement on a standard that serves to block an invention. So huge uptick in that people need to be mindful. So whenever you're using a standard, oftentimes a video codec or again audio or something that you may not have developed but are incorporating into your product. I think Matt's point about indemnity can't be underscored more. In that, I have cases right now where the underlying manufacturer is not standing behind their product that they sold and was incorporated into a final device. So having those contractual obligations nailed down at the beginning is vital. IP contributes to volatility in the public stock market. When something happens, there are options traders and short sellers who are monitoring the PTAB docket and the district court docket. And you can see that, the breaking news where a stock has already moved 30, 40% based on something that's happening in a court trial. So, for example, the recent Apple litigation where Google was involved in paying for access to Apple's ecosystem. When that verdict came down, the stocks of both companies moved significantly, and these are being monitored in real time. Um, as we said, hedge fund participation is increasing, and the bottom line for 2025 through 2030s. If you're a founder and you're raising money, or you're a public company or an investor allocating significant funds, you need to treat IP as a core financial asset and not just a legal checkbox that you're going through. David, next slide. Okay, so this one, I think that what I'm going to do is I'm going to add some points onto this because it gets a little bit detailed. But basically, it's how to identify if you are looking to monetize your IP portfolio, how to go about it, separating core IP, non-core IP. Um, as a rough gauge, 60 to 90% of most large patent portfolios are classified as non-core. And those are typically the ones that are being sold off and monetized and often end up in a NPE's hands where they've taken the claims and they're asserting them and recasting them. The core IP is, central to your company, so that's less likely to be sold off in such a way. So things that we can do total addressable market analysis. We can mine patent portfolios to find the best assets and get the most value out of those assets. There are a variety of different types of vehicles that can be used to monetize those assets. Some of them are faster, happening in 0 to 6 months, where others are longer duration, 12 to 24 months. Associated with that is the rate of return on the investment. The longer duration sometimes comes out with a potentially higher ROI. So there are different things that you would need to consider when looking at something like that. So I would say that, if there are CFOs out there in the audience, I would say that, the best CFOs treat dormant patent assets exactly like they would treat real estate or underutilized factories. So they should be balance sheet assets that should be either used or sold. So again, it's important to engage with counsel that has experience in these things and can walk you through the different variety of options that you have should you come to a point where you would want to monetize some of your R&D and IP assets. I think that is all. I think we're moving on to questions now, right? Yes. So do we have questions?
Yeah, it looks like there are some questions here. Some of these we answered already. Maybe we can get in this one. What are some tips for a startup company struggling to raise money and to protect their IP, especially when deep pocket companies go after them? And I'll say, this is a challenge. There's no doubt about it. And that's why, I think taking the lessons we heard today as an early stage company, you need to know the landscape, and you might not have money to do a full freedom to operate analysis, but you can at least spend some sweat equity on Google patents and do some keyword searching or engage. We work with early stage companies to engage kind of in right size searches for them, which aren't the same as a multinational, multi-billion-dollar medical device company. So I think you've got to get your own patents in order, and you got to be aware of your competitors, and you have to know that the VCs, if they're going to invest in you, we work with a lot of VCs and investors. IP due diligence is one of the most important check boxes because nobody wants to invest in a company that's just going to lead to a lawsuit 3 years, 5 years, or 10 years down the road. I don't know if Matt or David, do you have anything else to add on that?
No, I think that covers it. I mean, it as you say, it is a challenge, but it's not an insurmountable one. I think that there are two issues in this question. One is how do you protect your IP, and two is what happens when a deep-pocketed company goes after them. I think that when you're faced with a company that may be infringing on your IP and you don't have the ability to fund that litigation, I think that that's when you contact your counsel and look at your different options in terms of, as I said, there are, private equity firms. There's a variety of vehicles out there that can assist. Of course, they're going to want their return as well. But, if it's a meritorious case, there are certain ways to navigate that, and and they're worthwhile.
And the only thing I'll add to that is that, with sometimes with small companies, certain of the practical items that you can take away from today are actually easier to implement. And so if we're going to put a silver lining on an admittedly challenging situation to find yourself in, take advantage of the small size now. Get your document, management under control. Make sure you appropriately train your employees from the outset. Those are simple, easy things to do that are actually easier to do as a young company than as an already established player in the market.
I think one follow-on question that we had there is if you do find something when you're doing your patent landscape analysis, how should you document it and what should you do to protect yourself from litigation regarding whether it's non-infringing or you think the patent might be invalid? So we'll turn that over to Matt and David.
Well, I think the obvious thing that you can do is you can have counsel prepare what we call an opinion. And that opinion will say exactly what whoever this questioner put into his question, which is to say, we don't infringe. We've considered the issue. We've had competent counsel consider it, and we don't infringe. Our product does not infringe your patent. And also, we think the patent is invalid for XYZ reasons. And that goes to what I was getting at earlier, discussing, this concept of willful infringement. And one way you can combat that is by showing that, look, we considered the issue. We're not intentionally infringing. We did the analysis at the time, and we concluded that no, we don't infringe, and or the patent is no good. It should never have been issued in the first place.
And I would just add that, it's often an area where, the question is the business decides to proceed, but oftentimes we'll see in a freedom to operate opinion, some issue where it causes the company to maybe do a minor redesign to get around those claims. So at least the scope of the landscape they are operating in, and what patents are out there. Certainly, having a non-infringement opinion is useful, but oftentimes, maybe a small redesign of some aspect could be equally useful or more useful.
And I know we went a couple minutes over, but we covered a lot of ground today during this webinar, and there were a lot of questions, and we appreciate everybody's participation. Maybe as a closing statement, we'll make Dave and Matt and myself will do one sentence on what's in store for patent litigation as we turn the page on the calendar and look ahead to 2026. And I think I just say I think these trends are going to continue, and there'll be more and more patent litigation. Matt?
Dave, I think that's hard to argue with, as I'm thinking of my sentences. It's going to be more, more, more. That's what we're going to see.
Yeah, and I would echo that. I think that with the state of the Patent Trial and Appeal Board, I'm going to be making many more trips down to Texas this year because I expect there to be more litigation filed.
Great. Awesome. Well, thank you, Dave, Matt, and David, for the great presentation today. I think it's clear that 2026 will be bringing us more. And as a reminder, everyone will be receiving the email today with the webinar recording and the PowerPoint slides. Again, thank you for joining us and have a great day. Thank you.
Thanks, everyone.
Take care.